All right, you're back.
Always a bit surprised when people send me non-binding district court decisions, especially when I've given them appeals court decisions that are binding from the state of Wisconsin. But hey, that surprises me.
Ben,
You can hear me talking or no?
I can hear you loud and clear.
Great.
Your client is not a protected class employee. She's an at-will employee. Act 10 applies to her. Unfortunately, because of that, Laudermiller does not apply. I mean, if you want to go up to the Wisconsin Supreme Court, maybe with a new justice, you might be able to get them to.
If you want to rely on a non-binding district court decision, as opposed to the appeals court decisions that I've given you, that's one thing. But what you're doing right now is making an a priori decision on the evidence. This is evidence of bias. And more than that, you're assuming facts that are not in evidence, all of which
This has
you can't
nothing to do with
under,
facts.
excuse me, sir, under the grievance procedures here.
This
And
has nothing
again,
to do with
that just
facts.
on that alone is completely inappropriate. Again, the
You can
impartial
object all you want. Stop.
hearing officer
Now it's
may
my
not
turn to
act as
talk.
mediator, nor make
You
any
are
attempt
so
to
far
mediate
off on
this
what the law
dispute.
is that applies. Act 10 is what applies. I don't like Act 10 personally, but we're stuck with it. Okay? The rationale that is in the Marks case applies to your client's case. We
Again,
have to
that
apply
rationale
the
is
grievance
not,
procedure. We're going to move forward with you just going about the grievance procedure and whether or not there's a rational basis for the termination. If you want to challenge Act 10, you may do so. But I'm not going to allow you to keep on wasting our time talking about Laudermiller when it doesn't even apply. You're wasting my time and everybody else's time.
right. So again, what you're trying to do is use a non-binding district court case where you have binding circuit appeals courts and Supreme Court cases from Wisconsin. And this would be the same as if you were applying the reasoning of a circuit court. That's not binding on anybody here.
I'm very well aware of what
Now,
binding
I don't know
authority
that
is
you
and what
are.
isn't. Do you want
Again,
are you
what
done
you're
with
saying has
Dan Grady
no
or not?
precedential value of any kind.
Are you
None
done with
whatsoever.
Are you done with Dan
For you
Grady,
to
or do you
say
want
that therefore, and again, to spring this on us in the middle, and I get it. I mean, that's fine. You want to do your legal thing here. That's okay. But for you to spring this on us and then tell me as a fact without hearing from us or hearing any additional evidence or hearing even what's required in there or allowing us to make a showing, you're a priori deciding ahead of time without any facts and evidence, that's evidence of bias.
Ben?
So-
You said my turn. You sent me by email this morning your pre-trial or pre-hearing brief.
That's correct.
That had Laudermiller in there. In the time that you were asking questions, I went on and I pulled off the Marks case. I'm very familiar with Ms. Marks and this case, know the case quite well. That's how I pulled it up so quickly. It is what I'm trying to show you is the legal issue that you have that we are having a little bit of a discord with here. And I'm trying to get back on the right path. Okay,
No,
I'm
you're
trying to help
assuming
you.
that there's facts and evidence here that she doesn't have a property interest. That's what's happening here. And you've decided that you've disrupted this hearing, derailed the hearing for today, and said here that you've decided a priori without any basis of evidence that she is not covered and has no property interest. And to say that that's the problem here, that's what's called an evidence of bias. You have nothing on the record to support this legal decision that you're now making here, and yet you're making it anyway. That is what we call an evidence of bias. Again,
She's not a
it's
part
an
of the union. That's the problem.
I'm trying to explain to you what the problem is. You have made a legal determination here without hearing all of the evidence. or even making a decision as to, again, whether or not she's got a property interest in this case. That's what the problem is. So you've just put here on the record, we've got it here recorded, that you have decided that she doesn't have a property interest without a sufficient basis to establish that. You're also deciding here on the record that this case, again, non-binding case, is binding on you and that this is the law.
No, that's not what I said. Your client is a jail administrator, correct? That's what she was. Based upon that classification, Act 10 applies. She is an at-will employee.
You tell me where you got that on the record.
She's a jail administrator. Who do you want to call as your next witness?
I've got something more. Thank you.
Are you done? Any more?
I'm not done. No, thank you.
Okay, who's your next witness?
I have more to get on the record. Thank you. The impartial hearing officer may not overturn the county's decision to discipline or terminate based upon his or own personal judgment or opinion regarding the matter. Moreover, the impartial hearing officer may not determine a decision to discipline or terminate did not have a rational basis based on the county's failure to implement or follow concepts of progressive discipline or just cause in whole or part in making the decision to discipline/terminate the employee. And finally, the impartial hearing officer must recognize all the county's policies, rules, procedures, regulations, and may not modify or disregard the same. So again, if you've had anything on the record that shows that she, as you've just said, she's a jail administrator, therefore she's at will. Again, we're saying that that is an a priori evidence of bias. It's clear that you've made a determination on that issue before hearing the evidence on that. So that invalidates this hearing and is obvious evidence of your bias in this case. And again, it doesn't have to be real or not. All we have to have on the record is that you've made a decision in absence of any fact. So now with that, I'm finished with that objection. We are not done with Mr. Grady, so we are ready to continue.
All right, do you want to call Mr. Grady and get him back on?
He is back on.
Connecting. Okay, Mr. Grady, are you there?
Yep, I'm here.
Okay, Attorney Hitchcock Cross was asking questions. You're still under oath. You can continue with your questioning.
Okay,
I don't know if there was a question pending, but we'll just start over here. Okay. So how was Kim Lavasseur confirmed as jail administrator, if you know?
I was not employed by the county at that time.
So you're unaware?
No, I don't know.
Okay. Now, Did you ever have any conversations with Mr. Brennan regarding bypassing him as sheriff?
Did not have conversations with Mr. Brennan.
Okay. And so you didn't get any of his feedback on Miss Lavasseur, is that true?
That's correct.
Okay. And the only basis upon which you had to make your decision was information given to you from Mr. Zupke, right?
From the investigation conducted by Detective Pierce.
Okay, but that's into the alleged assault, not the employment investigation, right?
Well, they're tied together.
How?
Her inaction during the assaults is what led to her termination.
Okay. And you were aware that Miss Lavasseur reported the assault to the actual sheriff, Mr. Brennan?
Yes, I'm aware of that.
Okay. Did you discuss that with Mr. Brennan anytime?
No,
How did you become aware of that?
as I stated earlier, Sheriff Zupke, then Chief Deputy Zupke, told me about it. He'd been bypassed also.
How do you explain that?
He was not informed of the assaults until much later.
Okay. And is that because Miss Lavasseur told the actual sheriff or something else?
I don't know what Miss Lavasseur and Sheriff Brennan spoke about.
But you do know she told Mr. Brennan, right?
I've been told that that's the case, and I guess you're confirming it.
Okay, and you were told that before you made the decision to terminate her, right?
Correct.
Okay. Was there ever an internal jail report that was completed?
I don't know.
Okay. Did you ever investigate to find out whether there was an internal jail report ever completed?
No.
Okay. So Miss Lavasseur could have investigated, but you would not have known, right?
Correct.
Okay. And she could have determined that no discipline was warranted, but you wouldn't have known, right?
Theoretically.
Okay. And she could have made all those decisions in conjunction with the sheriff, but you wouldn't have known, right?
That's true.
Right. Okay. And in fact, you took no steps to find that out, right?
I did not. I don't know of any report existing. No.
Well, because you didn't talk to Mr. Brennan about it, right?
Correct.
And you didn't do any independent investigation on your own, right?
Not on my own. No.
Okay. Did Mr. Lindsay talk to Mr. Brennan, if you know?
Not that I know of. That would be. You'd have to ask them.
Well, you got the report, right?
I got the report, but I
Sure,
don't know what to. I can't talk to other people's conversations.
Sure. Did the report indicate whether they had talked to Mr. Brennan or not?
I don't believe it did.
No. Okay. And did the report indicate whether Miss Lavasseur had talked to Mr. Brennan at all?
I don't remember.
Okay. Who was interviewed for the as part of Mr. Lindsay's investigation?
The inmates involved, correctional officers involved.
Mr. Lindsay and let's say interrogated those inmates or somebody else?
It was Mr. Pierce.
Okay. So who did Mr. Lindsay talk to?
I don't know everybody he spoke to.
Did he speak with Zupke?
Yes, I believe so.
Okay. Did he speak with Brennan?
I don't know.
Okay. But you never asked him, right?
No.
Did he speak with Lavasseur?
I believe so. Yes.
Why do you believe that?
Well, he had to find out her side of the story. What happened?
How do you know that he found out her side of the story?
I don't know. I'm making a supposition.
Okay. And based on that supposition, you terminated Miss Lavasseur?
Based on her failure to do her duty, we terminated her, yes.
Can you answer my question?
I just did.
Based on that supposition, did you decide to terminate Ms. Lavasseur or something else?
Based on this, as I stated before, based on the results of the investigation, we made the decision to terminate Ms. Lavasseur.
And your supposition that Mr. Lindsay had talked to Ms. Lavasseur, right?
I don't really think that takes much, that's really relevant.
Is that a yes or a no?
Maybe
His answer
some
was he didn't
fraction.
No objection to the badgering.
Well, it's not, the answer is not responsive. So if we're gonna get a responsive answer, that's fine, but until then, we're going around in circles here.
Ask a question and just re-answer. Thanks.
I sure will. So before, and I appreciate your comments on what's relevant and what's not, but if you'd still answer my question, I'd appreciate it. So again, you made the decision to terminate Ms. Lavasseur in absence of any knowledge of Ms. Lavasseur's side of the story, right?
I made the decision to terminate Ms. Lavasseur based on the results of the investigation.
Which also were absent any discussions with Ms. Lavasseur, right?
I did not talk to Ms. Lavasseur, no.
And you knew you didn't make any attempt to find out whether or not Mr. Lindsay did, right?
I did not attempt to find out if Mr. Lindsay did.
Okay. And did you ever find out if the sheriff deputy ever talked to Ms. Lavasseur?
I don't know if they did or not.
Okay, well, isn't that critical to finding out what happened, to talking to Ms. Lavasseur?
Again, I didn't conduct the investigation.
Right, but in order to make the decision, don't you have to know whether or not, what Ms. Lavasseur's side of the story is?
Mr. Cross, Hitchcock Cross, again, we are in a right to work state. I don't need to know anything else. I don't need a reason to terminate somebody in a right to work state.
Okay, I appreciate that.
That is our state statutes.
Okay. Perfect. I think we might leave it there, but we'll be back there, and looks like I got another question coming. Hold on.
Not sure.
Okay. So, and to be clear, since you didn't need a reason, it's also fair to say that you didn't have a reason, right?
Objection to the misclassification of the witness's testimony.
Sustained. Just re-ask the question.
Okay. So you didn't talk to Miss Lavasseur. You didn't talk to the sheriff, right? You talked to the non-elected undersheriff who you were secretly in communications with, right?
I wouldn't say secret. I was not secretly in communications with him.
Well, it was a secret from Mr. Brennan, wasn't it?
Mr. Brennan, I don't know what Mr. Brennan knew or doesn't know.
Right, but you testified you made the decision not to tell him because the new sheriff was coming in, right?
No, I did not say that. I said we decided not to tell. Made the decision not to tell him. I didn't give any reason why. You're making an assumption.
You do notice your testimony here is recorded, right?
Yes, I do.
Okay. Now, when you decided to terminate Ms. Lavasseur, you didn't actually have any rule violations in mind that she had committed, right?
again, if you look at the letter she received and the statement on our website, there was a whole bunch of rule violations.
Okay, but you didn't have that until,
Until January,
When did you first see those rule violations?
in January,
Okay. Mhm. But that's in the letter you're referring to is dated February 20th, right?
the what I'm referring to is on our website. You can look it up on your computer right there.
Okay, and so based on that knowledge, it's on February 27th that you wrote this response, right?
Yes,
Okay, and did you participate in the drafting of that response?
yes,
Okay. Now, if Mr. Zupke said that he made the final decision to terminate Miss Lavasseur, is that false?
Yes, he finally agreed to terminate Miss Lavasseur.
Okay, but it's false that he made the decision, right?
No, it's not false. It was a joint decision.
Okay, and if he says that he woke up on the morning of January 20th and made the decision to terminate Miss Lavasseur based on that meeting, that's false, right? The January 19th meeting, just for the record.
I don't know if he did that or not.
Okay, keeping that in mind, can you answer my question?
I just did. I don't know if he did or not.
Okay, I'll re-ask the question. If Sheriff Zupke said that he made the decision to terminate Miss Lavasseur on January 20th after waking up after the meeting on January 19th, that would be a false statement, wouldn't it?
Again, I don't know what he thought waking up.
Okay. When I say if, that's a
I understand that, but
hypothetical.
I cannot say what goes on in somebody else's head.
Right, but you can say what's true, right?
I can't say what he was thinking that morning.
You can say whether or not he made the decision to terminate Miss Lavasseur that morning, can't you?
Yes, I can say that.
Okay, did he make that decision that morning?
On or about that morning.
Okay, but again, you're testifying here today that you're the one who made the decision to terminate Miss Lavasseur, right?
Yes, ultimately, I'm the one who makes that decision.
Okay,
Let's move on. This is, I mean, you gotta look at the reasons for terminating and whether or not there's a rational.
well, we don't even know who made the decision.
Ultimately, I made the decision.
What does that mean?
Ultimately, I'm the one who's empowered to terminate a non-represented employee who's not unelected. Who's
The
unelected.
sheriff is not the appointing authority, is that right?
To my understanding, no.
Okay, what policy or procedure gives you that authority?
State statutes.
Okay. And is there any Ashland County policy or procedure that determines who the appointing authority is for the sheriff's department?
It follows state statutes.
Okay. How does
Wisconsin
it follow state
statute
statute?
5918, if you want to look it up.
Okay.
Sub 2, duties and powers.
Duties and powers. Uh-huh.
Other than Milwaukee County, in every other county, the county administrator is the CEO of the county.
It says the sheriff in there?
The sheriff is a constitutional officer. That's a separate section. And he's responsible for deciding who the deputies and who he swears in as a deputy. You get
Okay,
into an
and you see
interesting
that in
gray
here.
area when it gets into the non-protected employees within the jail. I get that much. I can appreciate that, but technically it's the administrator's call.
I don't see what you're saying anywhere in here that says the county administrator is in control of the sheriff's department office.
He is in charge of the non-sworn employees. Okay, because a sheriff, and the sheriff is under 59. Where is the sheriff? Because he's a constitutional officer. So the sheriff is under, looks like 59, 26, and 27. And then the administrator is under 18.
Right, and neither of those things say that the administrator has the power to terminate non-sworn law enforcement or sheriff's department employees.
Who are you saying has the authority to do that? If it's not the administrator, who are you saying has the authority to do that?
I'm not putting that, it's governed by county policy. That hasn't been put into evidence yet. It's again, this is evidence of a priori decision-making.
Well, if you're the one saying that she was wrongfully terminated and filing a grievance because she was wrongfully terminated, I'm assuming you're trying to say that the administrator didn't have the authorization? What are you saying? I'm not following you here.
You asserted to me a legal conclusion that he had the authority to do something under a state statute.
Correct.
I responded to you that I saw no such authority in that state statute. And then I also said that this is evidence of a priori decision-making because, again, you're assuming that knowledge of the county policies, procedures, et cetera, without.
No, Attorney Cross, it's not a policy. That is a statute.
I understand that. And where in there does it say that, because again, it can be changed by policy. So I'm asking you, you're citing to a law, I'm asking you for where it says what you say, and then you haven't provided me with that.
I don't know I don't think that 5918 can be altered by.
Okay, great. So we'll go back to the gray area then. So, again, Mr. Grady, what county policy can you point to that says that you're able to terminate members of the sheriff's department?
I don't have to point to any policy. It's state statute.
Okay. So is that you unable to point to any policy?
No, it's my role as administrator to be able to terminate any employee who is not elected or represented by the union.
Okay. And what bylaw, ordinance, anything on the county level that says that you have that authority?
Mr. Carlson just cited you the state statute.
So you're unable to point us to any authority at the county level. Is that right?
That's correct.
Okay.
State statute
Thank
takes
you.
precedence.
Okay. And so again, if Mr. Zupke said that he would have made the decision to terminate Miss Lavasseur after the 19th, that would be false because Miss Lavasseur had already been terminated by you on the 19th, correct?
No, that's not a correct statement.
Okay. How could Miss Lavasseur have been terminated after she was terminated?
Again, she was terminated as jail administrator and offered the position as correctional officer.
Okay. But again, you never hired her as a correctional officer, or did I miss something?
I'm sorry, can you repeat that question?
Sure. So I guess to be clear, she's still a correctional officer as of January 20th or something else?
She was offered that position and did not accept it.
Okay. I think we got that clear. Okay. So again, if Mr. Zupke says that he terminated her after that meeting, that would be false, right?
Again, can you rephrase the question?
If Mr. Zupke said that he terminated Lavasseur's employment after his meeting with her on the 19th, that would be a false statement, wouldn't it?
Yes, that would be incorrect. I was the ultimate decider.
Okay. Now, it says here in the February 16, 2002 response to grievance filings that Zupke specifically requested whether Lavasseur would like to continue her employment as a correctional officer or else resign from the county. Lavasseur left the meeting with Sheriff Zupke without providing any response as to her intentions on continued employment with the county. After this meeting, it was concluded that trust between Lavasseur and the sheriff's office could not be regained. As a result, Lavasseur's employment with the county was terminated since she had not accepted continued employment as a correctional officer. Is that a true statement?
Yes, that's the correct statement.
Okay. So the problem is this sentence here, it says, as a result, Lavasseur's employment with the county was terminated. So which is it? Was she terminated before the meeting or after the meeting?
She was terminated as jail administrator beforehand, and then later terminated as a county employee, period.
Even though she didn't have the job?
It was hers if she wanted it.
Okay.
All right, we've gone through this long enough. I understand. I get it, Attorney Hitchcock-Cross. I get it. Let's
Okay.
move on. I get it. I get your argument.
Now, it says up here, when
Frankly,
confronted with questions as to the jail's investigation into these inmate allegations, Lavasseur did not take any responsibility for any lack of compliance with jail policies. Did I read that part right?
It sounds correct.
Okay, but in fact, that had no part in your decision to terminate her, right?
I'm sorry, I couldn't hear that.
I'll read it again.
No, your last statement, I couldn't hear.
That statement, whether or not the allegation that Lavasseur did not take any responsibility for any lack of compliance with jail policies, that did not play any part of your decision to terminate her on the 19th, right? Or prior to the 19th.
It was the reason we terminated her.
Okay.
Her inability to perform her job is the reason we terminated her.
That's not what it says. It says Lavasseur did not take any responsibility for any lack of compliance with jail policies. Okay?
That's her not doing her job.
That doesn't say that, sir. It says Lavasseur did not take any response when confronted with the question as to the jail's investigation into these inmate allegations. Lavasseur did not take any responsibility for any lack of compliance.
Yeah.
Right?
That's a correct statement.
Okay, so that statement, it cannot be factually accurate with your other statement that you made this decision to terminate Ms. Lavasseur prior to the 19th, right?
I made the decision to terminate her as jail administrator
Okay,
prior to the name.
all right. So again, I'll just read out the whole paragraph so we're clear. Kim Lavasseur's management of jail operations culminated in an incident involving allegations of sexual assault between two inmates, which ultimately led to her removal as jail administrator and termination of employment with Ashland County. After investigating this matter, the sheriff's office identified several instances where jail staff failed to follow appropriate jail policies and where inmates likewise violated jail rules without consequence. Did you hear that?
Yes.
Okay, is that describing Miss Lavasseur's conduct as jail administrator or something else?
Describing her conduct as jail administrator.
Okay. After, let's say, when confronted with the questions as to the jail's investigation into the allegations, Lavasseur did not take any responsibility for lack of compliance with jail policies. Did you hear that?
Yes,
Okay, and you testified that you did not speak to Kim Lavasseur, right?
no, I did not.
No, okay. So in fact, that's a false statement.
Objection, it is not. It's assuming that no such facts exist.
Sustained.
Well, no such facts existed at the time you made the decision, right?
Objection, no. That's assuming facts do not exist.
What does that mean? Assuming facts did not exist? That's not a thing, sir.
Facts that do not exist.
I just read the sentence out to him. I just confronted him with his own statements. His own testimony is that he made the decision without talking to Kim Lavasseur.
And his testimony is not that no one spoke to Kim Lavasseur.
Right. And these discussions, he also said that the investigator did not speak to Kim Lavasseur, nor did Mr. Zupke to his knowledge.
He never testified to that the investigator did not speak to Miss Lavasseur.
Okay. When, sir, do you believe that Miss Lavasseur was confronted with the questions as to the jail investigation into those inmates?
I don't know. I didn't conduct the investigation.
Okay. Instead, Lavasseur deferred responsibility for compliance, but you helped write this document, didn't you?
I helped, I read it over, yes.
Okay, and you ensured that everything was true in this document at that time?
It was true to my knowledge at the time.
Okay, so how did you have knowledge that she was confronted with the questions as the jail investigation into these inmate allegations?
Because I have to believe those around me.
Okay, so you had at this time, but when you made the decision to terminate her, you saw a document that said that Sheriff's Department employees confronted Miss Lavasseur with allegations and she did not accept responsibility. Is that true?
I was told that. I didn't have a document.
Okay, and that happened again before the 19th?
Before of January, yes.
And who told you that?
Both the sheriff and corporate counsel.
You mean Mr. Zupke, right?
Yes.
And who was not the sheriff at that time, right?
In January, he was sheriff.
Okay.
He took office January 3rd.
Okay, so then, according to that, this conversation would have had to take place between January 3rd and January 19th, right?
Yes.
Okay. Do you have any evidence that such a conversation happened?
No, I don't have any evidence.
No. Okay. Okay. And it says that Ms. Lavasseur did not recognize her role as being ultimately responsible for the actions of the jail staff working under her administration. Is that true?
Yes,
How do you know that?
because that's what I was told.
Okay. And this lack, and again, you heard that from Mr. Zupke or somebody else?
I heard it from both Mr. Zepke and corporate counsel.
Okay. now I'm going to keep going. It says, in recognizing that Lavasseur's shortcomings as jail administrator were mainly caused by lack of adequate and effective management skills, coupled with their long service with the jail prior to promotion as jail administrator, Sheriff Zupke recommended allowing Lavasseur to return to the position of correctional officer on January 19th of 2023. Corporation Counsel provided Lavasseur with notice that she was being terminated as jail administrator and explained to her that the county intended to rehire her in her previous position as correctional officer. Lavasseur was advised to meet with Sheriff Zupke to discuss her removal as jail administrator and the possibility of continuing her employment as a correctional officer. Is that a true statement?
Yes, that's correct.
Okay. In this meeting with Sheriff Zupke, Lavasseur again did not accept any responsibility for the incidents leading up to her termination as jail administrator. Is that true?
To my knowledge, that's true,
How do you know that?
because that's what I was told by the sheriff.
Okay, that's Mr. Zupke, right?
Yeah, I was not in the room, so I can't say what the two people spoke.
Okay, instead, Lavasseur stated that Sheriff Zupke was not, well, there's a recording of that. Have you heard the recording, sir?
No, actually, I haven't.
Okay. And Lavasseur stated that Sheriff Zupke was not being truthful in his recount of those incidents. Is that a true statement?
I'm sorry,
Lavasseur stated that Sheriff Zupke was not being truthful in his recount of these incidents.
I believe I heard Miss Lavasseur say that.
Okay, when did you hear that?
I read it in the Daily Press.
Okay. What steps have you taken to investigate whether those statements are true?
No steps were taken.
Say that again?
I did not take any steps.
Okay. Now it says Lavasseur left the meeting with Sheriff Zupke without providing any response to her intentions on continued employment with the county. After this meeting, it was concluded that the trust between Lavasseur and the sheriff's office could not be regained. Is that true?
Yes.
Okay. Did you make that decision?
The Sheriff Zupke made that recommendation, but ultimately I made that decision.
Okay. And then as a result, Lavasseur's employment with the county was terminated since she had not accepted continued employment as a correctional officer. Is that true?
That's correct.
Okay, which is true, that she was terminated because she had not accepted continued employment, or that she was terminated because of the lack of trust from the sheriff?
Both.
Okay. So when it says as a result, what is that? What are we supposed to take away from that? As a result, Lavasseur's employment with the county was terminated since she had not accepted continued employment as a correctional officer. What do we take from that?
That she didn't accept employment as a correctional officer.
Okay. Now, have you ever taken any steps to investigate Sheriff Zupke as chief deputy at any time?
No.
No, okay. And then although he was the supervisor over the jail administrator, he was not responsible for the jail administration in any way?
He was.
Okay. So why was Kim Lavasseur terminated and not, or disciplined and not Sheriff Zupke?
Because Kim Lavasseur went straight to Sheriff Brennan and kept Brian out of it.
I got it. Okay. Now, at that time, do you know whether or not, I guess, and to be clear, you never took any steps to confirm whether or not that opinion was true, right?
Again, I saw the police report from the investigation. So yes, I saw that. So I know it's true.
And the police report, it says that Ms. Lavasseur purposely kept information from Mr. Zupke. Is that true?
Yes, it does.
Yes, it does?
I believe it does, yeah.
Okay, are you able to identify where in that it says that?
No, I'm not. Again, I don't have my computer with me, where I work files with me.
Okay,
I'm
but
going
that
on
would be-
memory from last December.
and that's the assumption upon which you decided to terminate her?
That she didn't do her job. And her actions put the county in a huge financial problem.
Okay, and what financial problems did her actions supposedly cause the county?
Any one of those inmates could have sued us.
Have they sued you?
No, they haven't,
No, they haven't. And why could any one of those inmates have sued you?
because she didn't do her job and keep them safe.
Okay, so all it takes is for somebody not to do their job, and then, all right, let me put it based on that. Based on your understanding of this alleged sexual assault, that the county could be sued. Is that true?
Yes, they could be.
Okay, and do you think they'd be found liable?
Do I think the county would be found liable?
Right,
Did you say? I don't know what a jury would decide.
okay. And what did the investigation ultimately determine as to the facts of the assault? Did it occur or no?
Yes, they did occur.
Okay. Was there any criminal action taken against the suspect?
No, there wasn't.
Why not?
The district attorney decided not to proceed.
Okay. And why not?
I don't know. You'd have to ask the DA.
You
Let's
never
move
saw any
this-
report on that?
Let's move this along because that is completely irrelevant.
And that's Mr. Carlson speaking?
Yes, it is.
All right.
Whether or not a DA can prove beyond a reasonable doubt and whether or not someone should be disciplined are two different things.
Okay, but that's the question, is you knew that the DA had not decided to press charges when you terminated Ms. Lavasseur, right?
Yes, because the conduct still happened, whether it was criminal or not, it still violates jail rules.
Okay. Now, if Ms. Zupke had, I guess let's be clear, did Ms. Lavasseur fail to initiate an investigation?
She did not do anything to prevent the assaults from continuing to happen. And even if they were consensual, they still violate jail policy.
Okay, now I got it. So the actual rule that she supposedly violated was not preventing the sexual assault from happening.
The actual rule she violated is listed on that document. There's a number of them.
Okay, and do you believe that she reported the okay. Can you tell us which one she violated?
Attorney Cross.
Objection is the
Stop,
document.
hold
speaks
on,
for itself.
stop.
Yeah.
In the February 16th response, it has in there the policy sections.
Sure, which one? It does have several policies. For example, the jail administrator shall ensure that the custody manual is reviewed annually, updated whenever necessary, and staff trained accordingly. How did she violate that policy?
Hold on, let me look at the document.
So now you have access to it, huh?
Which
Okay.
bullet point are you?
No,
on?
I have access to our county website,
I can
Which
share
has-
my screen with this. It's right
which
here.
has it on there.
There, I shared the screen there, Dan.
Okay, great. So,
So which bullet
So, yeah.
point are you looking at?
The first one,
well, obviously, if the staff were not trained accordingly, this thing would never have happened,
and how do you know that?
because it doesn't happen in other jails very frequently.
Oh, okay. So if she had trained them, then this could not have happened. That's the statement? All right.
And not over months.
Okay, let's look at 10-8 3.2. Supervisors and managers are required to follow all policies and procedures and may be subject to discipline for failure to promptly and fully report any known misconduct of a member to his immediate supervisor or to document such misconduct appropriately as required by policy. Okay?
Yep.
Now, do you know whether or not she reported this? You do know that she reported this to her, to the sheriff, correct?
Yes, that's correct.
Okay. And you also know that this was documented or something else?
I know that her immediate supervisor is the chief deputy.
How do you know
Who
that?
she- Because it's in her job description.
Okay,
Mr. Grady, can you move your finger from the camera? again?
Oh, I'm sorry. It's how I'm holding my phone.
all right. So sir, I'm gonna point you to this Mr. Carlson, this is policies and mission policies and job description 2.
I'm sorry, what did you say?
Mission policies and job description 2, page 7.
Okay. Give me exhibit 11 once I find it.
Sure.
There it is. Do you want this up on the screen? Well, where did you go? Where did Ben go? Ben, do you want this up on the screen?
Sure.
I can share screen in just a minute.
You know, because I'm not logged in.
Ugh.
Okay, what's the question?
You on page 7, please? All right. You see this?
Yep.
And as county administrator, right, you're responsible to know all these, right?
I know most of them, yes.
Okay, and it says here, immediate supervisor, do you see that?
Yes,
That's for the corrections lieutenant?
yes.
Okay, you want to correct your answer?
No, it says chief deputy there.
Okay, what does this say?
It says sheriff and chief deputy. That's a
Okay.
plural.
Okay. Okay. So if Miss Lavasseur told Mr. Brennan, that's somehow not sufficient, is that right?
It says and.
Okay, does it say she's got to tell Both of those people?
That's what the word "and" means.
Okay. So the issue wasn't that she didn't tell anybody. The issue was that she, although she told the sheriff, she didn't also tell the chief deputy?
That's one of the issues.
Okay. Now it says here, the jail administrator is directly accountable to the sheriff and the chief deputy for implementing all the sheriff's orders and direction concerning the operation of the jail. Do you see that part?
Yes,
All right. So now if the sheriff told the corrections lieutenant on what to do for the investigation, that would be sufficient, right?
if the sheriff gave the jail administrator a direct order,
Right.
well,
That
the
would
sheriff has that
open the
prerogative.
chief deputy, wouldn't it?
Yes, it would.
Okay. And that's part of the reason why you bypass the sheriff during this investigation, isn't it?
Objection to the extent that misclarifies any prior testimony. Misclassifies.
Just go ahead and answer the question.
I'm sorry, can you repeat the question then?
That's the reason. That's also the reason you decided to bypass the sheriff and not talk to the sheriff with regard to the Lavasseur investigation, right?
A reason.
Okay. And again, it's your knowledge that she had already gone to the sheriff and reported their accusation, or the accusation of sexual misconduct was a reason to discipline her, or sorry, a reason to bypass the sheriff and then eventually to discipline Miss Lavasseur, right?
A reason.
Okay. All right. So let's look here at responsibilities. This is page 2 of 12, please. All right. So I'll go to sheriff. Responsibilities. This is 103, and this is one of the positions descriptions that you're responsible for overseeing. It says the sheriff shall be considered the ultimate authority for the provision of this manual and shall continue to issue general orders which shall modify the provisions to which they pertain. Did I read that part right?
Yeah, that's correct.
Okay, so that means the sheriff, whatever the sheriff says goes, right?
Basically,
Right, okay. So if the sheriff tells Kim Lavasseur that her investigation is fine, then her investigation is fine, correct?
that's correct.
Okay, so in fact, what you and Mr. Lindsay and the chief deputy were doing here was undermining the statement here that says the sheriff shall be considered the ultimate authority for the provisions of this manual and shall continue to issue general orders which shall modify the provisions to which they pertain, correct?
I don't think we undermine them.
Okay, explain to me how bypassing the sheriff can allowed him to continue to be the ultimate authority.
When I find out about something that jeopardizes the county, it's my obligation to go to corporate counsel and investigate further.
Is it also your obligation to bypass the duly elected sheriff?
In some cases, it may be.
Okay, is there a policy or procedure for that?
No, there's not.
Okay, does it say the sheriff shall be considered the ultimate authority unless the county administrator decides that he's not?
There's no policy that says that.
Okay, and in fact, there's no rule that allows you to do what you did, right?
There's no rule that doesn't allow me to do it either.
I don't know how you read ultimate authority, but I read ultimate authority as nothing higher. Is that the same? Are we on the same page?
I read my authorities. I answer to the county board, not the sheriff.
Okay, and we're talking about the sheriff's department, right?
Again, I answer to the county board, not the sheriff.
So, okay, so Miss Lavasseur should have contacted you as well?
She should have contacted the chief deputy.
Okay. And again, you knew that she contacted the sheriff. You knew that sheriff was the ultimate authority. You knew the sheriff had the power to determine who she actually reported to and who she didn't report to. And you were also aware that the sheriff didn't have any problem with the way that the investigation was going on, right?
I don't know what the sheriff had a problem with or not. Again, I didn't speak to him.
Uh-huh. And that was all a purposeful action that you did before you learned any of this information, right?
I wouldn't say it's purposeful. Sheriff Brennan could have come to me.
He could have come to you to know about your secret investigation of one of his subordinates.
If Sheriff Brennan could have told me about the incident himself.
Oh, so are you disciplining Kim Lavasseur for Sheriff Brennan not coming to you?
All right,
No,
stop,
we're just-
stop. We are drifting way off base here. Let's keep it on whether or not there's a rational basis for the termination.
Well, terminating somebody because of somebody else's actions wouldn't qualify as a rational basis, would it?
I think that last question was whether or not you were asking him whether or not he was disciplining someone else.
So my question to you was, isn't it true that the sheriff oversaw the investigation that Kim Lavasseur started into the sexual assault?
Yes, I believe that's correct.
Okay. And so on that basis, if there was any violation regarding the investigation or the allegation or the alleged deficiencies by Ms. Lavasseur, that would have been overseen by the sheriff at that time, right?
At that time,
Okay. But while that was happening, you and the deputy sheriff and the attorney for the county led a separate disciplinary policy without notice to the sheriff or the subject of the investigation, correct?
we gathered facts.
You got no facts from either the sheriff or the subject of the investigation, correct?
Correct.
Okay.
And to clarify that question, was that Administrator Grady himself did not, or that no one did?
If he saw it, let's see it. If you got some evidence, let's see it.
I did not see anything.
Okay. Okay. And so, again, knowing that Ms. Lavasseur went to the sheriff, knowing that the sheriff had approved her actions, you then decided to terminate Ms. Lavasseur because of potential liability to the county, correct?
Objection to the extent it misstates Mick Brennan's testimony. He testified that Ms. Lavasseur should have advised himself and Mr. Zupke as chief deputy of this investigation.
Sustained.
When did he say that?
He testified that Ms. Lavasseur should have notified Mick Brennan and Brian Zupke of this sexual assault allegation.
Who said that?
Mick Brennan.
Who's saying that Mick Brennan said that?
Mick Brennan said that Mick Brennan said that.
Who's
Attorney-
talking now?
Hold on, Attorney Lindsay.
Now I understand. That's
Now
Mr.
Attorney
Lindsay's
Carlson.
assertion. Okay, I don't believe that that's true. This is one of the rules they said at the beginning.
Are we gonna proceed?
What's your next question? You're muted.
Was there a ruling?
Yes,
And what was the ruling? How about
I
that?
sustained the objection regarding Mick Brennan's testimony.
Good thing we've got the recording. All right, sir, you've got, and I just want to point you here to this responsibility section. And it says, this is where it says the sheriff shall be considered the ultimate authority. And then if we just look on what you quoted and put on the website there. It says 103, quote, the jail administrator shall ensure that the custody manager manual is reviewed annually, updated whenever necessary, and staff trained accordingly. But you omitted the part where it says that the sheriff is the ultimate authority, right?
You're right, that's not in there.
Okay, and you knew that the sheriff was aware of the jail administrator's actions with regarding to training, right?
That's what I've been told.
Okay. So again, failure to promptly and fully report any known misconduct of a member to his immediate supervisor or to document such misconduct appropriately as required by policy. Do you see that?
Yep.
And she documented such misconduct appropriately by telling the sheriff, right?
She did
Objection.
not tell the chief deputy.
Okay, again, it says or. So I know you know the difference between and or, right?
Yes,
Okay, and we also went over the fact that her immediate supervisor could have been changed by the sheriff at any time for any reason, right?
I'm not sure that's the case, but
Well, do you want to read it? How
you,
it
no,
says that he's
you
the
said,
ultimate
you
authority?
said that. Mr. Hitchcock Cross, you said that, I didn't. I'm not sure the sheriff can unilaterally change a job description.
Okay, well, let's just go. The sheriff shall be considered the ultimate authority for provisions of this manual and shall continue to issue general orders which shall modify the provisions to which they pertain. Does that clarify your understanding?
My understanding is the county board can also change it.
Okay, did that happen?
It did not happen that I know of, but they can.
Thanks for that information. Now let's look at 11.32. Supervisor shall initiate a complaint based on observed misconduct or receipt from any source alleging misconduct that, if true, could result in disciplinary action. Do you see that?
Uh-huh.
And you know that she told the sheriff, right?
I know she didn't tell the chief deputy.
Okay. Initiate complaint based on, so again, there's no reason to say that she didn't initiate a complaint based on the observed misconduct or receipt from any source alleging misconduct that, if true, could result in disciplinary action, right?
Right.
It doesn't say that she has to tell the chief deputy there, right?
It says it in her job description.
We've been over this. It
We
says
went over
chief
part of
deputy
it.
And sheriff.
No, right. And it also says the sheriff can modify that at any time. And we also know that the sheriff talked to her, because we have his testimony, and that he approved everything that she was doing. And he also knows that. And you also know that. Number 111.5, supervisors shall inform and ensure that all formal and informal complaints are documented on a complaint form. Do you have any reason to think that she didn't, for the actual policy? Okay. All right, let's look at it. All right, here we go. Let's look at the actual one here. So I'm on page 4. It says, supervisors shall ensure that all formal and informal complaints are documented on a complaint form. The supervisor shall ensure that the nature of the complaint is defined as clearly as possible. All complaints and inquiries shall also be documented in a log that records and tracks complaints. This log shall include the nature of the complaint and the actions taken to address the complaint on an annual basis. The jail administrator should audit the log and send an audit report to the sheriff or authorized designee. Is that an accurate representation of the true policy?
I'll take your word for it.
Okay. And again, you're the county administrator, right?
I can't remember every single line.
Okay. So, but again, and you reviewed all these before you had them put up on your website, right?
Yes,
Okay. So, and how by, and what information do you have that Ms. Lavasseur did not document her complaint or the complaint?
well, the chief deputy didn't see it.
Okay. So then we'll go on from there. Again, the sheriff saw it, but the chief deputy didn't see it. Is that true?
She hid it from the chief deputy.
Ah,
She
okay.
hid the whole incident from the chief deputy, which she was supposed to report to, according to Sheriff Brennan's own testimony.
And not according to the policy that we've gone over 3 or 4 times, right? Right?
Even Sheriff Brennan said she should have reported it to the chief deputy.
And how do you know that?
Mr. Carlson, Mr. Lindsay just said it.
Oh, okay. Now, let's keep going here. The jail administrator is responsible for ensuring that scheduled and unscheduled inspections, visits, and contacts are implemented to minimally include compliance with the policy. Did I read that right?
Yes, he did.
Okay. How did she fail to do that?
There were continuing assaults.
All right, let's look at that inspection here. Inspection. The jail administrator is responsible for ensuring that scheduled and unscheduled inspections, visits, and contacts are implemented minimally to include, says the general conditions and overall climate of the facility, the living and working conditions of the inmates, communications between administrators, managers, supervisors, staff, inmates, and visiting the public, compliance with policy, safety, security, and sanitation concerns, inmate concerns, and meal services. Did I read that right?
I don't have it in front of me, but that sounds right.
Okay. And how do you know that she was not completing inspections?
There were repeated assaults occurring.
Okay, is it
Over a month
possible
period.
is it impossible for assaults to happen while she's inspecting?
She or her correctional officers are supposed to be doing that.
Okay, again, my question is it possible for an assault to happen while scheduled and unscheduled inspections are also happening?
It's possible for a single one, but repeated ones over months.
How do you know that?
because that's what the evidence showed.
That it was impossible for there to be scheduled inspections and for this to have occurred, or something else?
Well, I guess anything is possible.
Okay. Did you have any information that Ms. Lavasseur was not conducting scheduled or unscheduled inspections?
I did not personally see it that.
No, okay. And then we'll go down to 2155. Each staff member conducting the inspection or tour shall document the activity in the appropriate station form or facility log. The log shall include any significant findings that indicate remedial action or training may be needed. Is that an accurate reflection of the policy?
It's an accurate reflection of what's on the screen.
Okay. Is that an accurate reflection of the policy?
To my knowledge, it is.
Okay. Well, let's just look here. I'll read the entire one. It says
Well,
each staff-
concede, yes, that's what the policy says, Attorney Hitchcock-Cross.
Thank you for that. It also says significant issues of security or safety shall be addressed promptly. Commendable or successful actions that should be replicated elsewhere in the facility should also be noted in the log. The sergeant shall review the logs daily and ensure that any deficiencies noted are addressed or forwarded up through the chain of command as appropriate, and that the commendable actions are also appropriately addressed. Isn't that the complete policy?
It sounds like it.
Okay, so in fact, it's the sergeant, not the jail administrator, who's responsible for the daily logs, correct?
Objection to
Yes.
the misclassification of that policy. It specifically says each staff member conducting the inspection.
Speaks for itself. Let's
Yes.
move on.
Okay, but again, it's the sergeant there, sir, that is responsible for reviewing those logs, correct?
Yes, I believe so.
Okay. And Kim Lavasseur was not a sergeant, right?
No, she is not.
Okay. And you knew that at the time?
Yes, I knew that at the time.
Just once.
Mr. Carlson, can I take a 2-minute break?
Do we know how much longer we're gonna go, or?
Yeah, let's
I just
talk,
gotta go to the restroom.
yeah, for, real quickly, so it's 4:15.
All right, I just,
How
back.
much longer are you anticipating this will take?
I just gotta go to the restroom real quick.
Where did Ben go?
Yeah,
I don't know. I'll be back in a second.
yes. Has he left?
Where did he go?
He's right here.
Didn't your guy go to the bathroom?
Okay, so real quickly, I just wanted to talk where we're headed here. How much more questioning do you have for Mr. Grady? I just want
We're
to,
pretty much done.
I'm sorry?
We're, I assume, close to being done.
Okay. So why don't we wrap up with your questioning of him and then, what time do you guys have to leave?
As soon as possible. Whatever.
Okay. Why don't we wrap up your question of Mr. Grady and then we'll call it a day and reconvene 8:30 tomorrow morning.
But we'll finish with, I didn't understand that completely. We're gonna finish with Mr. Grady entirely for today or something else?
Just your questioning of him.
Sounds good. Well, why don't we just keep going? I mean, why don't we just keep going? That'll
I
also
just had to go to the
minimize
bathroom
the,
here, so you don't need any bursting bladders here, so if you need to take a minute, go for it.
right, he's going to the bathroom now. I'm about to go myself. So now that we're all clear on that, I'm just saying, I think it'd be better to finish him off today.
Well, how much time are you gonna take?
I don't think very long.
Uh,
I'll get it done.
All right, let's finish.
Let's
him
do
up
it,
and then
yep.
we'll do it. That's fine.
I need to make a phone call.
Okay, I'm back.
Just gotta wait for the attorneys to get back in.
Oh, okay.
Do you have much dealings with Lori Carlson?
With Lori, who?
I'm sorry.
What?
Lubinsky.
So, you know, I've had a number of 1983 actions that I've brought that she ends up on the other side of.
She died. I get her with school districts almost exclusively. I've never had her with anything else.
Well,
She defended an N-word case of ours some months ago on the theory of you don't want to make a federal case out of everything. She won that one. That's I thought that would get you. I love to make a federal case out of everything. What are you talking about? Well, the jury bought it. That's your crab jury over there, I'll tell you.
okay, what happened to Mr.
I
Green?
think Dan got knocked off for a second.
Oh, here he comes.
Yeah.
Okay, Mr. Grady, is there? Hello?
Hold on, I lost Bluetooth here.
Gonna be an air horn open? So which Packers are in town? Aaron Jones?
Aaron Jones, Samori Toure,
Who's that?
receiver, rookie last year, never played, and two others that I don't specifically recall.
Mr. Grady, you back yet or no?
Hold on, I'm having problems here. My headset's not working.
All right, so let us know when you're ready.
Oh. Well, it's out of power, so I just have to use the phone I have here.
We can hear you well, if
Yeah,
that's
we-
the question.
Yeah, we can hear you just fine. Your batteries are wearing out, that means we're going to more.
Can somebody say something?
Yeah, we can hear you, Dan.
Okay, I'm good now.
All right,
All right, we ready?
hope we need Ben back. Okay, we're ready to go. You need to unmute.
Rookie Zoom court. Here we go. All right. I just want to turn your attention back to this letter that's up on your website. If you've got that there, I'd appreciate it.
I got a question. Why is that on the website anyway?
You know, to defend my client, what are you talking about? I'm sorry, I guess that was represented to Mr. Grady. Why is this on the website?
In response to, the Ashland Daily Press.
Oh, okay. Did you give any statements to the Ashland Daily Press?
Just the statement.
Okay, and have you read all the articles?
Yes,
And then everything in them's true?
I disagree with most of the articles.
Okay. All right, just 1 second, please. So, sir, you see these Ashland County Jail inmate handbook?
Yes,
Okay, are those the rules that were currently in place at the time of your termination of Miss Lavasseur?
yes,
Okay. I'm gonna draw your attention to our exhibit. It's called Ashland County Jail Rules and Regulations. If we can pull that up, please.
This will be exhibit 12.
Mhm. And if we could just look to the bottom of that first page there. All right. Do you see this document and the revision date?
yes.
Okay, what's the revision date on this document?
2021.
Okay, and is this the active jail rules that are in effect currently?
I believe so.
Okay, so then just comparing this document to the document that you put on your website in response to the Ashland County Daily Press. Are you able to explain to me the general rule, inmate will not enter another inmate sleeping area unless authorized by staff? Do you see a section 9.1 there?
Yeah, yeah.
Where is section 9.1 in this document? Oh, sorry, that's the document that you posted to the website. But how about
Right.
into the Ashland County Jail Rules and Regulations that are actually controlling?
Objection to these questions, to the extent that the document you have highlighted here is called the Ashland County Jail Rules and Regulations. The document that is cited in that letter and is produced or cited in our Exhibit 6 is the Ashland County Jail Inmate Handbook. They're two separate documents.
Okay. Again, we can let him testify.
That's the reason for the difference.
Okay, again, you can let him testify or we can go through witnesses.
You can ask a question, but I mean,
Okay,
let's
so
go.
here,
Go ahead.
I guess we'll show them. Is the inmate handbook that is produced as a witness, is that still in effect today?
I believe it is.
Wait, flip over to that, please.
Okay, and how do you come to that conclusion?
That I have not seen any updates.
Okay. All right.
And what will we identify this as?
I think we already have this one. Is this one already marked or no?
No.
Well,
I haven't introduced that one. If they want to introduce
yeah, I
it.
mean, that's, we'll have to wait until it's introduced by the county.
Right.
See what-
Okay.
Okay. Are you done?
All right. Yeah, we're finished. Thank you.
Okay, Attorney Lindsay.
All right. Dan. In the conduct and the course of your work as county administrator, do you often rely upon the opinion and the recommendations of your employees and other employees of Ashland County?
Yes, I do.
And in making the determination here, the decision to terminate Ms. Lavasseur, did you rely on those opinions and recommendations of other employees?
Yes, I did.
And you trust their opinions?
Yes, I do.
In, just to clarify where some apparent confusion is regarding who made the decision to terminate Lieutenant Lavasseur. Is your testimony that you have the statutory authority to terminate Ms. Lavasseur?
Yes, I do have the final statutory authority.
But in making that decision, you deferred to and relied on the recommendation and the decision of Sheriff Zupke?
Yes,
So it is possible that both Sheriff Zupke said he made the decision to terminate, and you also stated that you made that decision to terminate.
yes, and I concurred with that.
Is the jail administrator position at Ashland County a protected employment?
Not at the current time.
Is there any requirement that the jail administrator get a due process hearing prior to termination or any other employment discipline?
No,
In fact, the Ashland County does the general Ashland County employee handbook apply to the position of the jail administrator?
yes, it does.
And on page 47 of that employee handbook, is this to your understanding, is it a fair and accurate statement that says this policy is not a guarantee of employment, a guarantee of any rights or benefits, does not create or grant covered employees with a property interest in their employment or tenure rights or any kind, and does not constitute a contract of employment express or implied, unless specifically required by another statute or code. The county's employment relationship with employees eligible to use this procedure is at will, and employment may be terminated at any time for any reason, with or without cause, and with or without notice, at the option of the county or the employee. Is that an accurate representation of the county's employee handbook?
Yes, it is.
Hold on. We don't have that as an exhibit. do we?
No,
Can we make it an exhibit?
it is part of the county's, it's the grievance procedure.
So we need to mark that as exhibit 13 then. Okay, continue.
Okay, all the reasons that are stated in the February 17th letter that was provided to Ms. Lavasseur, did all of those reasons for her termination exist prior to the decision to terminate her?
Yes,
And those were not manufactured or created after the decision to terminate was made?
no, they were not.
And the decision to terminate Ms. Lavasseur was not made until after Sheriff Zupke assumed the position of sheriff, correct?
Correct.
Prior to his, strike that. Have you reviewed Never mind. Strike that. In discussing with Sheriff Zupke, the decision to terminate Lieutenant Lavasseur, did he specifically say that no one had spoken to her about this issue?
No, he did not.
In fact, Sheriff Zupke testified that he did speak to Ms. Lavasseur prior to her termination, correct?
He did. He did.
And Detective Pierce's investigation report states that he spoke to Ms. Lavasseur about these issues, correct?
Yes.
Are you required to bring your decision to terminate a non-protected employee before any county board or committee?
No.
Objection that calls for legal conclusion.
We asked the question.
To the best of your knowledge, are you required to bring the decision to terminate a non-protected employee before any board or committee at the county?
No.
I'm gonna attempt to clarify the timing and the language used in the letters for termination that were provided to Ms. Lavasseur. The initial letter was provided to her on January 19th, correct?
Yes, that sounds correct.
Okay, and at that point is when she was removed from the position of jail administrator.
Yes.
And at that point, she was not rehired as a correction officer, correct?
No, she was offered the position.
Yes. So at that point, she was not employed with Ashland County.
Right.
And then following up after that, the decision was made to rescind that offer to reemploy her as a correction officer.
Correct.
So in giving her notice of that, the county notified her that she was in fact terminated immediately when she was removed from her position as jail administrator, correct?
Yes. Yes.
So that effective date of termination was that January 19th.
Yes.
And just state strike that. I have no further questions.
Anything in redirect?
Yes. Yes. Can you show the county's exhibit that says full investigation file for Brandon Tudor Jordan?
Okay, I gotta mark that one. That is gonna be 14. And just so you know, I think what I'm gonna do is if I have to include anything from this exhibit in my decision, I will use initials of the
No,
individual.
we don't have any objection to that. It's hard to hear you, but we're, by all means, let's protect those.
Yeah, I don't know, I don't know how much of it public information people get otherwise, but.
Oh, I understand what you're saying, and I will, I'll just refer to them as the inmates, because I inadvertently said that name when I was talking about the exhibit name, right?
Very good, appreciate
Yeah,
it.
no, I understand. That makes perfect sense. Okay. And I guess just based on this answer, we may need to hold over till tomorrow or not. But have you seen this document, sir?
No, I've not.
I didn't hear you. What did you say, Mr. Grady?
You
No,
never-
I did not.
Okay, is this the investigation conducted by the sheriff's department or something else? And maybe we can go down further, because that might be made. Maybe just the second page there, Mr. Carlson. Is this the document you're talking about?
I'm not talking about any document.
You saw, it's fine. And my understanding is that you saw a investigation into the alleged sexual assault at the jail, right?
I saw a summary of a document.
Okay.
Document I saw was the summary.
Okay, and who authored that?
I believe that was Detective Pierce's summary.
Pierce, okay. And is this the Pierce full investigation or something else?
It was his investigation results at the time.
But that's, so my question is what, do you know whether this document represents the full investigation by Mr. Pierce or something else?
Objection to that, the witness testified he hadn't seen this document.
Fair enough. Do you see? Let's go to page 3, please. Do you see this heading there, Ashland County Sheriff's Department Incident Report Form?
Yes, I do.
Okay, and then the date on there is 10/23/22. Do you see that?
Yes, I do.
Okay, and the primary officer for there is Mel Aschbacher or something along those lines?
Yes,
Do you recognize him to be an Ashland County Sheriff's Department employee?
he's a correctional officer.
Okay. So, and you note the date here, 10/23/22, do you see that?
Yes,
Does that indicate that this, and is this the sexual assault that we're discussing here today?
one of them.
Okay. And does this, because Mr. Mel Aschbacher is a correctional officer, does this document demonstrate that there was an investigation into the jail alleged sexual assault as early as 10/23/22?
It documents that the incident was reported.
I'm sorry, I didn't understand that answer.
It demonstrates that the document says it was reported.
Okay. So this is a separate investigation from the investigation that you referenced, right?
This is something I haven't seen before.
Okay, and this is this investigation takes place prior to the hunting season, right?
Prior to deer hunting season, yes.
Okay,
Should clarify, gun deer hunting. This would be bow season.
Yes, that's correct. I'm sorry, gun deer season.
I
You're
think we
correct.
all knew he was gun deer, but yeah, I understand. That's fair.
Yeah, because bow season starts in September, so.
Yeah, I think we're on the same page. Okay. So then I appreciate that answer. We're gonna go back to that. I guess I'm just gonna ask Max straight out. Max, is the actual report that he's referring to in the deputy sergeant report, is that in your exhibits?
I don't know specifically what he reviewed. All of the findings in the investigation from Detective Pierce are here. Yes,
But this is also the Pierce investigation?
it's all together.
Are you able to tell us where one starts and the other begins, or no?
I think you could have done that, but I believe Pierce's report starts right here.
Which is
Awesome. All right.
Page
Well,
9.
based on that, I appreciate that. So I think the best thing to do is to then pause for today. And then we will have some more questions based on this report.
Why?
Okay, well, I won't be available tomorrow.
Well, hold on, time out. So you're wanting Dan to review this document and then ask questions?
No. I think that we should pause for today. I am going to ask him more questions based on this document. And given the length of this document, I'm afraid we're going to be here for some time. So based on that, I think we should pause for today.
And apparently,
Unfortunately,
Dan
I
is,
have to be at the Department of Revenue tomorrow. I have a different hearing at the Department of Revenue I have to be at tomorrow.
Well, that's strange because I thought we were just discussing postponing for today and not finishing Mr. Grady for today.
well, that's what I was
No,
kicking
we-
around,
we-
but apparently he's unavailable, so that ain't gonna work.
And we decided not to do that.
What-
Okay, well, do you want to break for like an hour and then we'll come back on this issue then, Mr. Grady? What's your preference here?
Why do you need a break?
Because I need to review this document. That's why.
The hearing is today.
Did you not already have this document?
I
thought-
got this on Monday night. This document is 50 pages, single spaced with quite a good deal of information. I have it's 4:43. I have been going since 9:30. And I would like to review this document and question this person on this document. So either way, I'm gonna need a break. And if he is not available tomorrow, then let's keep going today, but I'm gonna need a break. Right.
Well. Did I not see this in, maybe I didn't look at all these documents, just give me 1 second. The titles here. Not happy that we're having to do this on the fly. I mean, this is not being fair to witnesses, and that's a problem. In your amended witness list, you have in here Ashland County Sheriff's Office sexual assault investigations with attachments. Does that not include this?
Ben left again.
You went to go grab this report.
Where is that file?
I don't know, that's the
right.
policy, not the actual investigation.
All right, so that document wasn't searchable, so we had to run it through this search. That's what it's doing right now. So what's the plan, if any?
So I was under the impression that this was actually one of the exhibits that you were proposing in your disclosure of exhibits.
The one you're talking about is the, excuse me, the policy,
Okay. So it
not
is
the
in
actual
there.
investigation report.
So do you know what questions you might have that would,
Yes,
I guess, undercut the rational basis of the reasons for termination?
right. Well, again, there's two issues here. more than anything else, which is, he's saying, he said several times that he's relied on this report to form the basis for his decision. So again, he's also said that he relied on the evidence of other people. So we want to ask him questions about, and I mean, I get that there are, let's put it like this, if we're not interested in the inmates. So if that's part of the concern, I'd just like to lay that to rest. We absolutely want to keep that separate from there. The issue really is, he says that she didn't report it. He says that she was talked to by these investigators, and he said that he read that. So we want to ask him a lot of questions about what he knew.
Okay. So you're looking in the report to see whether or not Kim was ever interviewed by the investigators?
That was the first thing that caught my attention, absolutely. And also here, there's this document also shows, as far as I can tell now that he's explained it to us, that there's one investigation that happens on 10/23, like Mr. Supke said, and then there's also a secondary investigation. Now, it's been alleged that there was no investigation, or there was only one investigation, and that there is no 10/23 investigation. And so in fact, there is one, and we want to go in through what that happened, and because it appears that the jail staff investigated all of this and contacted the ADA and so forth, and that in fact, they're blaming her for things that they were well known to them and investigated. And then we'll compare that with the investigation that the deputy did. So now
Okay.
apparently we have two investigations, even though we were told there was only
I
one.
Hold on. I don't think there's two. I'm looking at this and you have an initial report that's made on 10/23 to
Right?
Ashland, I don't know how to pronounce his last name.
Mhm.
And then it picks up, so he doesn't do anything here. It picks up way into, looks like 11/29 with O'Donohue Mirandizing Jordan.
Right, but O'Donohue, so a jail officer would not be Mirandizing a
The 10/23 date is the date of the initial incident report. The full investigation goes on this for 50 pages, all under that same initial.
well, so there's
incident
another one that
number.
has a jail-related incident 11/12 of 22. So that seems to me to be, and that's created by Dustin Halverson, primary officer. So that's a separate
Where's that?
investigation is what it looks like to me, as
Okay.
opposed to Mel Ashebacher.
That was at the
Oh,
end.
that's it. Okay, so then there's, no, that's
So
still,
I see the shift happening between page 41 and 42.
Yeah, there are three incident reports, one 11/12/22, one 10/23/22, and one on 9/27/22. They're all put together. This is the packet that was sent to the DA's office with all of the evidence, all the information.
So are you stipulating that this is the investigation by the sergeant detective?
Yeah,
Where do you see the sergeant detective's name in here anyway?
all along the bottom. It is. Well. On the 23rd page.
what's on the?
Which is
20?
actually the 25th page,
Oh, yeah.
where Zach Pierce puts that he is the one who completed it.
Yes, nothing further, Zachary Pierce, 639. So is this the complete investigation that was led by Pierce that obviously involves others?
Yes, and that included his review of the reports of all the allegations. of sexual assault and misconduct going back to September 27th.
I don't see the sergeant's name here.
So what questions that would you have then further for Mr. Grady?
He disappeared again.
You can't keep leaving.
Where'd he go? It's muted.
He had to go get the documents. He had to print it.
Oh, I see. All right, well, let me use this opportunity to.
Dan, is there any time you'd have available to come back tomorrow, whether not right away or any time at all?
No, Matt told me it's gonna probably take the whole day.
There we go.
Max, I'm gonna run to the restroom again since Mr. Carlson's not there.
Wait, Dan, are you still there?
All right. What are there questions that you could ask a different witness that would provide answers to your questions, I guess? Oh, you're muted. Ben, you're muted.
What time is this hearing tomorrow? I'm willing to come early.
I can't come early.
What time can you start?
8:30 at the earliest. We had noticed it for 9, I think, in the Zoom.
Well, I can, yeah, I can't go any earlier than 8:32 because I gotta get kids to school.
Yeah, I have a quick hearing in Bayfield County at 8.
We could do it at 8:30. Dan, you're out tomorrow with a hearing all day long, or what's going on?
I think Dan briefly stepped away.
Okay. Are these questions been the type that can only be answered by Dan, or is it something that can be stipulated to? I mean,
Yeah, no, and I hear you, and I'm almost always going to be flexible, but if he's the decision maker here and we're going to reasonableness and what he knew, we got to get him on this. So, I mean, I see how they have the investigator lined up and so forth, but the key question isn't what the investigator investigated, it's what the county administrator knew when he made this decision. Yeah, I already got like 3 angry texts so far.
how many more witnesses do you have, Ben?
Very few. I mean, I think we've, I don't know what they have, but I think we've gotten to the crux of the issue here.
Okay, so Dan, are you back? I saw you.
Yes, I am.
Okay, so you're in a DOR hearing all day tomorrow, or what's going on?
Yeah, I'm in a DR hearing all day tomorrow.
Is there Ben, can you limit it to like 5 or 10 minutes where if Dan was able to sneak away for 10 or 5 minutes, we could, get it into that window?
Give me 20 and yes.
Dan, is that possible?
It all depends on the DOR.
Believe me, I understand it. They outrank all of us. I totally agree to that.
Yeah, I
Well,
mean,
let's-
I just,
Let's do this. Let's plan on doing that. Ben, if you could just get ready with your questions and then, Dan, tomorrow, when you have a little bit of time, give Max a call and we're gonna squeeze you in and
okay,
might just have to interrupt witnesses to get you in and we'll just do that.
Okay.
all right, I assume there'll be a lunch break at some point, so.
Yeah, if we can quickly, get whatever questions answered, that should work. Fair enough?
Okay, yeah, and I'm talking to my counsel tonight, so, I'll put that request to him.
Okay, fair enough. Is this like a legislative hearing or what the heck type of hearing is it?
It's the LaPointe thing.
Oh, God, okay. All right, fair enough. Okay, so let's break for the evening. Let's reconvene. Do you want to do 8:30?
Could we do 8:45? Just
8:45?
Sure.
Even 9 is fine. I mean, I don't know how much, and I don't want to speak for Mr. Lindsay, but I don't know how much more he has. I don't think we've got a full day between the two of us.
I'll be here at 8:45. If we start at 9, that's fine. And then we'll start with another one of your witnesses. Do you know who it's going to be? If we could have them ready to go right away?
I will have them ready to go. I'm not quite sure who it is, but we'll coordinate that. And be 100%.
Okay, fair enough. We'll
All right,
set up to you.
Thank you, everybody,
All right,
for
and
your
I'll-
flexibility. Have a good night.
okay, John, I will, tell Lori to be ready to open the door for you again.
I got her. She's here.
Oh, okay, okay,
Everybody's got to take care of recording. Good, because I don't want to be
All
responsible.
right, thanks, Ann.
yeah, thank you.
Thank you.
I'm not touching it. I don't want to be.
Yep.
Catching it, have everything deleted, so.
Thank you for staying
Oh,
late.
You can just leave the power on, it will go off by itself.
She's here to,
Laura's here.
Laura's here to.
Yeah, okay,
Thanks,
archive
Lori.
it, whatever.
Thanks, John.
all right, thanks.
Talk to you. Good to see you guys.
Go say hi to the Green Bay Packers. All right. Are you ready to go?
Did you close out the meeting?
No, I haven't touched it, so it's still recording, it's still doing it. I don't want to touch the wrong button. That's good, there we go, all right.
Okay, have a good night.
We're gonna start with, if we can get this one at 8:45.
Okay, you need it again tomorrow, okay?
Yeah, we're gonna start somewhere. 8:45 tomorrow. All right, we'll give you
You too, thank you.